Tuesday, in the most notorious criminal trial in Richland County, Dr. John Boyle is accused of killing his wife Noreen and burying her body.
The 12-year-old son finally took the stand.
Boy confidently told the jury it was his decision to testify against his father.
I heard a scream. I heard a thud. It was about this loud.
We, the jury, find the defendant guilty.
I decided at an early age that our trauma should not be what defines us. It's what we choose to do with it that does. I'm here to share my unique perspective on true crime, mental health, society, and popular culture, and always with a slight sense of humor. I'm Collier Landry, and welcome to my show.
That's a good question.
You are unmuted.
We're back on the record on the Karen Reed, Your Honor. We've got a question from the jury.
All right. So, Mr. Lally, I'd like to hear from the Commonwealth first about due and thorough deliberations.
I'm sorry, I didn't hear the last one.
I'd like to hear from the Commonwealth first about your view on whether the jury has conducted due and thorough deliberations.
Your Honor, while I understand that they have been at this for a while, I would submit that they have not, and I would ask the court not to make such a finding. Reasons for that, Your Honor, this jury heard, I believe, about 29 days or so of testimony, 657 different exhibits marked as evidence, 74 different witnesses who testified before them. And while I believe they've been out for somewhere in the vicinity of 22 or 23 hours, what I would submit to the court based on all of that, as well as the complexity of the issues presented to them, they really haven't even had 1 hour of deliberation equivalent to 1 day of testimony to each of the days of testimony that they've heard. So while they have been at it for a while, I would submit that based on the evidence and testimony and witnesses and the complexity of issues in this case, I would submit that they have not done a thorough deliberation up to this point.
Ms. Giannetti?
Our view is that it's time for Tucci-Rodriguez, Your Honor. They've come back now twice, indicating essentially that they're hopelessly deadlocked. The content of this latest message is that they have been over all the evidence. Previous message said they did an exhaustive review. This time they said that they have fundamental disagreements about what the evidence means, and it's a matter of opinion. It's not a matter of lack of understanding. This court, when you sent the jury out, encouraged them not to take a straw vote, encouraged them to go over all the evidence in a very methodical manner. I think all indications are that they've done that, and this is what Tucci-Rodriguez is for. We asked the court to get it.
Yeah. All right. I think this has been an extraordinary jury. I've never seen a note like this reporting to be at an impasse. I do find that they're now, with the additional time that they went out without coming back Friday saying that they were deadlocked, is due and thorough deliberation. So I'm going to give Tucci-Rodriguez. So are they ready to come in, Jody? So why don't I take a recess?
Take a recess, please.
All right. And then Nancy.
Court is in session. Please be seated.
All right. So, jurors, I am in receipt of your note. Judge Cannone, despite our commitment to the duty entrusted to us, we find ourselves deeply divided by fundamental differences in our opinions and state of mind. The divergence in our views are not rooted in a lack of understanding or effort, but deeply held convictions that each of us carry, ultimately leading to a point where consensus is unattainable. We recognize the weight of this admission and the implications it holds. So, Mr. Foreman and members of the jury, I have an instruction for you.
This is the
Our
Tucci-Rodriguez.
Constitution and laws provide that in a criminal case, the principal method for deciding questions of fact is the verdict of a jury. In most cases, and perhaps strictly speaking in all cases, absolute certainty cannot be attained, nor is it expected. The verdict to which each juror agrees must, of course, be his or her own verdict, the result of his or her own convictions, and not merely an acquiescence in the conclusions of the other jurors. Still, in order to bring 12 minds to a unanimous result, you must examine the issues you have to decide with candor and with a proper regard and respect for each other's opinions. You should consider that it is desirable that this case be decided. You have been selected in the same manner and from the same source as any future jury would be selected. There is no reason to suppose that this case will ever be submitted to 12 persons who are more intelligent, more impartial, or more competent to decide it than you are, or that more or clearer evidence will be produced at another trial. With all this in mind, it is your duty to decide this case if you can do so conscientiously. In order to make a decision more attainable, the law always imposes the burden of proof on the Commonwealth to establish every essential element of each indictment beyond a reasonable doubt. If you are left with a reasonable doubt as to any essential element of any indictment, then the defendant is entitled to the benefit of that doubt and must be found not guilty on that indictment. In conferring together, you ought to give proper respect to each other's opinions and listen with an open mind to each other's arguments. Where there is disagreement, those jurors who would find the defendant not guilty should consider whether the doubt in their own minds is a reasonable one, if it makes no impression upon the minds of the other jurors who are equally honest and equally intelligent, who have heard the same evidence with the same attention, who have an equal desire to arrive at the truth, and who have taken the same oath as jurors. At the same time, those jurors who would find the defendant guilty ought seriously to ask themselves whether they may not reasonably doubt the correctness of their judgment if it is not shared by other members of the jury. They should ask themselves whether they should distrust the weight or sufficiency of the evidence if it has failed to convince the minds of their fellow jurors beyond a reasonable doubt. I will now ask you, Mr. Foreman, and members of the jury to return to your deliberations with these instructions in mind. And as with my final instructions and the supplemental instructions I sent in, I will send in a copy of this charge as well. All right, so may that be marked, Madam Court Reporter, please. All right, so thank you. We'll send you folks back out to deliberate.
All rise for the court, please. Jurors, follow me.
So that is the Tucci-Rodriguez instruction. When the jurors cannot agree. It is the 2009 edition that I have here. We'll throw that up in a second. So you guys can see.
You are muted. Goodbye.
Goodbye. Here comes OnlyFan. All right. This is the Tucci-Rodriguez instruction as she just read. So you guys can check it out. That's page 1. Page 2. and page 3. And then there's the alternate instruction. But essentially, from my understanding, and again, I am, as you guys know, I'll go ahead and put it in the notes. I am, as you know, not a lawyer. Oh, wow. Melanie Little is 16,000 people watching. Of course she does. Good on you. I will go ahead and make her stream. Oh, Mark Federer is there too. It's Mark Federer talking. That's Mark Federer commenting. You guys can obviously check that out over on her channel. I was just going to log on to mine so I could give. There we go. Thank you, Court McNeil. Thank you. I can't put the notes in there. Oh my God, Collier, learned so much about you this weekend. It really tore me up. Oh, well, thank you, Robin Bragone. Yeah, no, that is why you come to this channel, because I am not a lawyer or in law enforcement or a psychologist, just a guy who's been through a lot of shit. But you get a different perspective on all of this as someone who is the son of a perpetrator and a victim. I'm here to give you my unique perspective because I think that's very important to have when looking at these cases. I think you guys realize that. And to you, those of you who are just discovering, yeah, they're not, I guess they're not covering the split. I mean, who knows if they will reveal that. Again, I don't know. I mean, Mark Bedrow is over there talking about it, and as is Melanie Little, both very competent attorneys. But thank you so much. And I was not necessarily going to stream this trial. I mean, I only started 3 weeks ago. I was very late to the party and even covering this case, but I found it very interesting, and I learned a lot being here with all of you guys. And apparently this Tucci-Rodriguez thing is unique to Massachusetts. It's not a common thing, but I learned so much from streaming this trial. It's been very good, and I've learned a lot. So thank you all for being here. But I'm going to keep this all open anyways. But yeah. Oh, there's Marisol making some noise downstairs. Of course she is. Let's see what our extra camera shows us. Oh, we can't see her. Oh, here we go. She's got her little toy. So glad I did. Met a lot of great people. Well, thank you so much. Again, that's the Tucci-Rodriguez document that I was just showing above. Judge Beverly Cannone just read. I don't know exactly what this all means as far as, is this going to be declared a mistrial if they cannot come to a verdict, essentially? Oh, yeah, I'm in the wrong. I got 2 computers going. I've got a second computer just to stream this channel, which was not necessarily an easy financial choice. Tucci-Rodriguez instruction or charge. So let's see what this means here. Okay, I'm going to just pull this up for y'all somewhere, and we will go over it. So stay right here while I do this. Come on, StreamYard. Again, multiple computers rolling at once. Enter studio. I'm going to mute. Stop my camera. There we go. Okay. I will remove this. We will pull up Boston. This particular thing. We'll read through this. And we'll go ahead and close this advertisement. Thanks for that. Okay. Can we see this? Fantastic. Can I do this? Nope, don't want to do that. So, Karen Reed judge reads formal instruction after jury says they're deeply divided and consensus is unattainable. Judge Beverly Cannone read the Tucci-Rodriguez instruction Monday and told jurors to continue deliberating. Oh, are they not going to give us any what the hell it's read? Well, that was okay. What does Tucci-Rodriguez mean? Let's go ahead and ask the Googles that. What does Tucci-Rodriguez do? If they're still unable to reach a unanimous verdict, the next step for the judge would be issue what's known as a Tucci-Rodriguez instructions. It's really a blast to the jury to say, consider the other side of the person opposite you and see if you cannot reach a conclusion that is unanimous. It says Attorney General Martha Coakley. Explain former Attorney General Martha Coakley. The three options: the prosecutor either drops the case totally, they decide to retry the case, even if they drop some of the charges, and the third, they can try to offer some sort of plea, offer, or agreement, said defense attorney Peter Eichen. However, the jury returns again to say if the jury returns again to say they are still deadlocked, the judge must declare a hung jury and dismiss them. So there you go. Again, just to cover it, if they are still unable to reach a unanimous verdict, the next step for the judge would be to issue what's known as the Tucci-Rodriguez instructions. And according to former Attorney General Martha Coakley in this article on WCVB, it says it's really a blast to the jury to say, consider the other side of the person opposite you and see if you cannot reach a conclusion. If you cannot reach a conclusion, because it just keeps jumping around, that's unanimous. Again, it's really a blast to the jury to say, consider the other side of the person opposite you and see if you cannot reach a conclusion that's unanimous, explained former Attorney General Martha Coakley. The three options: the prosecution either drops the case totally, they decide to retry the case, even if they drop some of the charges, and the third, they can try to offer some sort of plea offer or agreement, said defense attorney Peter Eichen. However, if the jury returns to say, that they are still deadlocked, the judge must declare a hung jury and dismiss them. So there you have it. Very interesting. Lots of craziness in the Karen Reed trial. Here we go. I don't see how the Commonwealth retries this case. I don't see how they reach a verdict. And, again, actually dropping the case would mean, total. I mean, as I said in the beginning of this, oh, sorry, guys. My eyes are itchy. As I said at the beginning, when I started covering this thing, it doesn't matter what decision the jury arrives at. No one's going to take it at face value. I think that people are going to be very polarized. They're still going to believe whatever they want to believe. She's guilty. She's completely innocent. Even though I would probably argue that a deadlock is more on the side of people presuming her innocence beyond a reasonable doubt. So that's just me. I'm sure that other people will take it in a different way. I don't see a lot. Yeah, well, it's also very early here, by the way. I mean, it's 8:19 now. I live on the West Coast, guys, just so you know. And yes, I yawn a lot because it's exhausting because I am on the West Coast and I also work very late at night. Even though yesterday was a Sunday, I'm working a lot while I'm trying to get all this done. And we had our live members only meet and greet yesterday too, which was fun. And we even did an impromptu live. I reached 50,000 subscribers, and thank you all so much for that. If you wouldn't mind, please click the like button while you're here. It helps with the channel. And I appreciate everyone being here. It is there's a thing. Would you guys like me to rewind what we just heard since I think there's some new people coming up. We'll go ahead and let's go here. For those of you catching up.
We're back on the record on the Karen Reed, Your Honor. We've got a question from the jury.
All right. So, Mr. Lally, I'd like to hear from the Commonwealth first about doing thorough deliberations.
I'm sorry, I didn't hear the last one.
I'd like to hear from the Commonwealth first about your view on whether the jury has conducted due and thorough
I have.
deliberations.
Thank you so much, Catherine.
Your Honor, while I understand that they have been at this for a while, I would submit that they have not, and I would ask the court not to make such a finding. Reasons for that, Your Honor, this jury heard, I believe, about 29 days or so of testimony, 657 different exhibits marked as evidence, 74 different witnesses who testified before them. And while I believe they've been out for somewhere in the vicinity of 22 or 23 hours, what I would submit to the court based on all of that, as well as the complexity of the issues presented to them, they really haven't even had 1 hour of deliberation equivalent to 1 day of testimony, to each of the days of testimony that they've heard. So while they have been at it for a while, I would submit that based on the evidence and testimony and witnesses and the complexity of issues in this case, I would submit that they have not done a thorough deliberation up to this point.
Ms. Giannetti?
Our view is that it's time for Tucci-Rodriguez. They've come back now twice, indicating essentially that they're hopelessly deadlocked. The content of this latest message is that they have been over all the evidence. Previous message said they did an exhaustive review. This time they said that they have fundamental disagreements about what the evidence means, and it's a matter of opinion. It's not a matter of lack of understanding. This court, when you sent the jury out, encouraged them not to take a straw vote, encouraged them to go over all the evidence in a very methodical manner. I think all indications are that they've done that, and this is what Tucci-Rodriguez is for. We asked the court to get it.
Yeah. All right. I think this has been an extraordinary jury. I've never seen a note like this reporting to be at an impasse. I do find that they're now, with the additional time that they went out without coming back Friday saying that they were deadlocked, is due and thorough deliberation. So I'm going to give Tucci-Rodriguez. So are they ready to come in, Jody?
Wait, you guys can't hear them? Or was he just talking low because he's not on a microphone? Could you guys not hear that? Is that the case? I'll rewind it because the volume is all the way up. Let me know. Okay, great. So you guys can't hear it. Yeah, Yannetti's not on a microphone, so you can't hear him. It's very hard to hear. I had to turn the volume up here as well on my speakers. Okay, great. And she'll bring them back in.
So why don't I take a recess?
Take a recess, please. All right.
And then Nancy.
And then we'll come back here. Watch the rest. Let's just make sure they're not into doing something. Okay, great.
Court is in session. Please be seated.
All right. So, jurors, I am in receipt of your note. Judge Cannone, despite our commitment to the duty entrusted to us, we find ourselves deeply divided by fundamental differences in our opinions and state of mind. The divergence in our views are not rooted in a lack of understanding or effort, but deeply held convictions that each of us carry, ultimately leading to a point where consensus is unattainable. We recognize the weight of this admission and the implications it holds. So, Mr. Foreman and members of the jury, I have an instruction for you. Our Constitution and laws provide that in a criminal case, the principal method for deciding questions of fact is the verdict of a jury. In most cases, and perhaps strictly speaking in all cases, absolute certainty cannot be attained, nor is it expected. The verdict to which each juror agrees must, of course, be his or her own verdict, the result of his or her own convictions, and not merely an acquiescence in the conclusions of the other jurors. Still, in order to bring 12 minds to a unanimous result, you must examine the issues you have to decide with candor and with a proper regard and respect for each other's opinions. You should consider that it is desirable that this case be decided. You have been selected in the same manner and from the same source as any future jury would be selected. There is no reason to suppose that this case will ever be submitted to 12 persons who are more intelligent, more impartial, or more competent to decide it than you are, or that more or clearer evidence will be produced at another trial. With all this in mind, it is your duty to decide this case if you can do so conscientiously. In order to make a decision more attainable, the law always imposes the burden of proof on the Commonwealth to establish every essential element of each indictment beyond a reasonable doubt. If you are left with a reasonable doubt as to any essential element of any indictment, then the defendant is entitled to the benefit of that.
Yes, I
doubt
realize that. We're
and must
replaying
be
it for
found
everyone.
not guilty
Sunshine.
on that indictment.
I know I'm behind.
In
Thank you for
conferring
pointing that
together,
out.
you ought to give proper respect
We've
to each
already
other's
covered it.
opinions and listen with an open mind
replaying.
to each other's arguments. Where there is disagreement, those jurors who would find the defendant not guilty should consider whether the doubt in their own minds is a reasonable one. If it makes no impression upon the minds of the other jurors, who are equally honest and equally intelligent, who have heard the same evidence with the same attention, who have an equal desire to arrive at the truth, and who have taken the same oath as jurors. At the same time, those jurors who would find the defendant guilty ought seriously to ask themselves whether they may not reasonably doubt the correctness of their judgment if it is not shared by other members of the jury. They should ask themselves whether they should distrust the weight or sufficiency of the evidence if it has failed to convince the minds of their fellow jurors beyond a reasonable doubt. I will now ask you, Mr. Foreman, and members of the jury to return to your deliberations with these instructions in mind. And as with my final instructions and the supplemental instructions I sent in, I will send in a copy of this charge as well. All right, so may that be marked, Madam Court Reporter, please. All right, so thank you. We'll send you folks back out to deliberate.
All rise for the court,
I'm
please.
curious why you say she's why she's corrupt as far as she's reading these instructions, because it's the law. She's following the law in Massachusetts by reading this, because basically once she gives this instruction, if they come back again, it's a hung jury, but she has to read this by law. And she did not agree with Prosecutor Lawley's assumption that or insinuation that the jury needed more time and everything like that. She agreed with the defense this time. She said, yes, and that she is now the prosecutor. Lawley asked for them to go back again and deliberate and not have the judge issue the Tucci-Rodriguez statement, and she refused. She agreed with the defense and said, I'm going to issue that statement, meaning that if they come back again, they're deadlocked. That's it. Hey, get off there. So I realize some people are feel that she's corrupt, but this decision was very much in favor of the defense. Again, I'm not a lawyer. I'm not a psychologist. I'm not in law enforcement. I'm just a guy who's been through a lot of shit. We'll hit the note again just so you guys know. But yeah, that's where they're at. So I'm not here to defend the judge, but I am here to let common sense rule the day. But that was a big win for the defense, because Lawley wanted them to continue to deliberate until the end of time, probably after the 4th of July, so he can get his guilty verdict or whatever he's looking for. But I think the judge has put the kibosh down. Like, if you come back again, which I would assume they do before lunch, then it's a hung jury. Which then leads, as we read in the article to describe all of this, which then leads us to the prosecution having 3 options left, which is they either drop the case totally, they decide to retry the case, even if they drop some of the charges, and the third is they can try to offer some sort of plea agreement, which they did initially in all of this mishigas with Karen Reed, which is why I think, look, I again, I'm not a lawyer, but one of the things that does happen, and there's a great documentary done by Brad Pitt in 2017, I want to say. I think somebody was a documentary filmmaker. Hey, come on, Puppins. I don't know why she's clawing my couch, but you need to not do that. I might have to go get her in a second. You're going to go to your playpen if you don't behave. There's a great documentary done by Brad Pitt. I think it was done in 2017 called The 13th. Talks about the criminal justice system. Okay, let me go get this dog, this crazy dog. Come on. Come here, crazy puppy. Don't do that. That's Eddie's couch. We don't do that. That's not a scratching post. Come on. No one trouble. Yeah, you think you're slick, don't you? She got a piece of paper. This is Marisol. She's here. She's a little frisky today. You want attention, don't you? You want attention. You're like, why can't we talk? Why can't it all be about puppies? Why can't it all be about puppies, right? I know. I know. Oy vey. She could care less. She is getting very bored. Are you bored? Are you bored? Daddy wasn't playing with you. Were you bored? Oh. Okay, here we go. Daddy's going to put you in here. We're going to get our Marisol camera going again. And let's find those TREATS. Let's see if we can give her a bully stick. That might keep her occupied for a while. Another word was Chihuahua Marisol. Chihuahua Marisol. Ooh. We'll give her a bully stick. Here, Puppins, you want a bully stick? A bully stick? Oh, good girl. Yeah. All right. No, you can't. Can you be good if I let you out? Will you be good? Take the treat? God, this whole thing. Are you kidding me? Common sense is not so common. Well, yes. I think we can all agree with that. That's for sure. That is for sure. Devil puppy. No, she's not a devil. She's a little precious. She's just frisky and feisty. She's a feisty little chihuahua. Anyways, yeah, looks like we're back in business. Well, we're back in the business of our good friend, OnlyFan, is back. Bully sticks in a holder, make it last longer. Oh, maybe I should do that. I believe the woman to her left, or camera left, I think is the victim's advocate that is in the court, that is there for the family. I believe they are in the courtroom there with them. Bully sticks in a holder. I'll have to get that. Our Tenderfield Terrier is the spitting image of Marisol. Oh, his name is Benji. Oh, Benji. Is he small like Benji? And we'll have to get a bully stick holder. And yes, common sense is not so common as we all think. It's not as common as we all think. And thank you all. We are at 50,200 subs so far. I really appreciate it, guys. I'll stop sharing this. Let's see if we can see what some other. There's been an increase in my messages coming in from scammers sending me invoices for things I never purchased, obviously trying to get a bite from people. It is July 1st. 4th of July is upon us, by the way. I would like to point out also that I am wearing my my hoodie. I was shamed over the weekend for my wardrobe by certain people, which was kind of funny to me. It was like, oh, okay, that's nice. It's a great way to get in my good graces. Let's insult people. And for being a YouTuber too. That was interesting as well. Never mind the fact that my latest film has won every single film festival for the last year and a half that it has entered. That's over 60 we've won, including Doc NYC, which is a massive documentary film festival. But it was kind of funny. The lady who was crying with the glasses is his mother. Got it. But yeah, she knows that there probably isn't going to be any justice for John O'Keefe. I again, as a son of a victim and a perpetrator, this is horrible for them. They're not going to get the closure that they seek. It's really sad. It's really sad. And it's not fair. And I mean, closure is sort of as I say, is a kind of a bullshit word a lot of times. Did I do something silly? Of course I did. Of course I did. Collier. Anyways, I don't know what I was saying. Kind of lost my train of thought. But let's see here. I guess I kind of got lost and then all the negative comments over the weekend, they sort of bugged me. But anyways, thank you guys so much. We're 50,000, almost 300, which is amazing. I greatly appreciate it. I hope you guys checked out my interview with Melanie Little over the weekend. Had some more content come out. my work schedule and travel schedule of filming. I was in Tampa and then Atlanta this last week. Really just kind of set me back, but I think we did a really nice job with it. I also love the thing. Yeah, I mean, here's the thing you got to know about the feds, right? See, money is the feds have nothing but time and money on their hands. So the fact that they've drawn any interest in this case, I don't see it. I think their investigations are going to probably yield quite a bit, which is, yeah, we'll see. But nobody knows what the feds know. But yeah, thank you so much. Yeah, it was a good. Catherine is in. Well, you're not in NSW, are you? You're in, if I remember correctly, you're in Melbourne, right? Melbourne. Oh no, it was actually more negative comments in my personal life too. I was being what would the word be? Not undressed. I don't know. Dressed down, I suppose. People have very interesting opinions about what you do for a living. So it was Court is a fantastic moderator. Court is the one who keeps the stuff rolling behind the scenes. 141 New South Wales coastal mountains. I have so many pictures of Oz. I wish I could share them right here, but we can't do that. We had I've been to the Three Sisters, yeah, and then the New South Wales coastal mountains. Is that like Wollongong, Catherine Billinghurst? I love Australia. Australia is, if no one has been to Australia, it is a beautiful country and probably the most pristine beaches I've ever seen in my life. In fact, I have this setting on my iPhone, and for the photos that come up, and I said, do like landscape photos as my backdrop. And all of them lately have been from my time in Australia. I got to go up and down the coast of the eastern coast of. Yeah, she is going to town with that bully stick. But New South Wales coastal mountains. I'm wondering if you're in Wollongong. I think we talked about this before, but we didn't talk about it here. Blue Mountains is where yes, you're 8 hours north of Wollongong. Oh, so you're north of Sydney too. Are you up past the reptile park? Probably. Well, they're idiots in real life. Yes, there are. It's okay. I mean, I wouldn't say this person's an idiot. I would just say that the comments were not particularly constructive. Were more based in their own sort of dissatisfaction with life than my own personal life. But I digress on that point. I digress. All right. Well, we're going to keep the OnlyFan on. I'm going to keep the Chihuahua cam on. I'm going to take my cam off because just for the record, I also have very good clothes and very good fashion sense. I might be wearing a hoodie right now, but no, I've this person just made a very snap judgment based upon a very limited scope in my life. I was like, okay, that stings. Take a cat nap, Collier. I can't take a cat nap. I've had too much caffeine. So we're going to get caught in Australia. China and Australia were quite similar. And there's a lot of Chinese who have moved into Australia as well, which is very problematic to a lot of Australians. Let me put back our OnlyFans. and he took me to Pink's to get he wanted a hot dog. I was like, I don't eat hot dogs. I'm not eating a hot dog. And I got a turkey burger, and the turkey burger was really good. But I remember seeing all these people lined up. I'm like, are these people just lined up for a hot dog? Are you serious? And yes, they were. They were lined up. They came from far and wide to go to Pink's famous hot dogs. It was pretty funny. Yeah, see, money, I would agree. It's a little bit of a thing. Everybody has their own issues, but that's okay. Forget about it. Yes, I will, Esmeralda. Thank you. Oz isn't quite tyrannical. To get to although I never know. Yeah, I think there was a lot of opinion about their policies during certain times of the last couple of years. Marisol, similar markings and same coloring as my Scooby. She reminds me of him. He was a 60-pound American Bulldog. Oh, Scooby. Thank you so much, C Money. I appreciate it. Casey Lee, thank you so much. Oh, the members only meet and greet is going to be on a live replay. In fact, the video just processed. I'm going to throw that up on not only the Patreon, but on the YouTube members section here. Are we done? Now we're going to get into mischief. Yeah. Now we're going to get into mischief. Oh. It's mischief time. You're done with your bully stick. You know, you still have some left. And now you're going to do the mischief thing. Is that what we're doing? Mischief. Okay. Okay. You want your bully stick again? Okay. Have your bully stick. I need to find a bully stick holder. That's what I said. Oh, there will be another one. They are every month, the last Sunday of the month at 3 p.m. Eastern time. Last Sunday of the month at 3 p.m. Eastern time. You can mark your calendars for that if you're channel members. Live meet and greets every Sunday, every last Sunday of the month. So whether that be the 21st, the 23rd, or the 30th, 31st, what have you. 21 through 31. I guess that doesn't make a lot of sense. 23 through there. I don't know. Well, I'm trying to take account February and the 31-day months. But yeah, 21 through 31. Yeah, I guess that would make sense. Just a reminder to those to watch. Oh, got it. Court McNeil. Oh, Court, great point. I guess maybe I'll edit that part out. Where is that in the convo time-wise? Part out. Might edit some parts of the replay out. But just a reminder, this is the insider info. Sometimes there's some inside info that is handed down, and that is supposed to be kept confidential, as you guys know. You want to go in your cage? No? Daddy doesn't really want to have to watch you while Daddy gets on the phone. Sorry, I missed the meet and greets. Yeah, it's okay. I try to post them now. We're posting them. We're doing them on the same day consistently, so hopefully people can set their schedules. We had a great turnout, though. It was really fun. Because you guys get to all interact with one another. We don't get in there. We don't get in there. I know you just want to get in trouble all day. All day. She will. She's a Chihuahua, so she'll be forever puppy, just like her big sister Blondie was. She was always she was hyper and very sweet and fun till the end. 18 amazing years with that little one. Yeah, maybe we'll get that with you too. Oh, you're so good. Daddy loves you so much. Yes, I do. Daddy loves you so much. Yes. OnlyFans is still rocking. I rock that hoodie. It is Aviator Nation, which is a very cool brand. That's why it has the 5 stripes. Which apparently these people were not familiar with either. I was like, it's Aviator Nation. How do you not know what Aviator Nation is? Especially when you live by the beach here in Los Angeles. Everybody wears it. and in the Hamptons too. I'm going to put back the OnlyFans. I'm going to take her downstairs. Blondie was a great one, though. We loved her very much. Okay, say bye for now. Bye for now. We're going to put the other camera on. Here's you want your bully stick? Daddy, go bring your bully stick. Daddy's going to put you in your house. Good girl. I love you. You're a good girl. I put her in her playpen. No sound. Yes. There was no sound for a second, Jen Thunder. And there's no sound now because, oh, would you guys want some music? Let's put our music on. That's what we need. What was I thinking? So silly. Very low. And we'll mix it up a little bit too. I'm going to go on mute. I'll let you guys chat amongst yourselves. I'm sure there's other channels that are talking and doing wonderful things. Hopefully you'll stay right here or you'll keep me open and you'll switch back when more things happen. We'll keep the OnlyFans on and I got to make some calls. So I might just go to my avatar.
You are unmuted.
Thank you. Be seated. Closing session.
22-117 Commonwealth versus Karen Reed.
All right, the jury is at an impasse. So we'll bring them in.
Wow. Well, it means Karen Reed's going home. That's good. Take that as a win. Oh, you guys probably can't hear me. Wow. This is wild. Wild. That means Karen Reed is going home, and we'll see what happens next. I mean, not.
All right, Mr. Foreman, I am in receipt of your note. Judge Cannone, despite our rigorous efforts, we continue to find ourselves at an impasse. Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges. The deep division is not due to a lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. I'm not going to do that to you folks.
Wow.
Your service is complete. I'm declaring a mistrial in this case.
Wow.
I'll be in to see you privately in a few minutes. So thank you so much for your service. Okay.
All right, so the court, please.
Wow. No justice for John O'Keefe's family yet. You know, Karen Reed walks free out of that courtroom. I mean, free-ish, but she's not going to. You know, it's better than a guilty plea. Better than a guilty.
All right, I'd like to pick a status date to find out what our next move is. So I'd like to come back sometime maybe the end of July. I understand people have vacation schedules.
Wow.
Can we come in the week of the 21st?
I'd imagine.
That's fine.
No, I'm just looking at my calendar. Could we do the 22nd at 2 p.m., Your Honor?
It's hard to believe, too, that statement. Like, more than one of us believe.
Is there another day that week? Could you do the 25th or 26th?
Unfortunately, I think I'm supposed to be.
What a waste of time.
Okay, the 22nd and the 24th are not great dates. So,
and these are the people that I feel the worst for.
Is that whole week?
no, that week's not good. The teaching that I cannot get out of.
Can we do August 7th, 8th, 9th? Any of those days?
No, we'll do the 22nd. We'll go back to the 22nd at 2.
John,
I can't let it go that long.
Because it's never gonna.
Ms. Little and I are not available on the 22nd. We have a hearing in Los Angeles on the 22nd.
Okay.
Proposing to appear remotely anyway.
He's like,
but for a status conference, I don't want to.
Jackson's like, I'm peace out back to LA. See y'all.
Okay.
Fuck this shit. I'm
So
outta
you and your client will be here in person, Ms. Gina.
fiasco. He's like, I am back to where things make sense. Going back to California. Aching in my heart.
Thank you. We'll see you then.
Wow.
And now we have an official ruling
Not
in the Karen
surprising.
Reed murder trial. It
Whew.
is a mistrial declared. And you see there Karen Reed hugging her father
Jeez.
shaking Alan Jackson's hand. Behind him in the red tie is attorney David Yannetti. And you can see off with their backs turned, that would be the O'Keefe family, who seemed, that's his mother right there in the blue and white striped shirt in the far background that you can see also hugging. They seemed rather emotional today. A mistrial after two notes. The first one came in at 11:30, saying in part, we find ourselves divided by fundamental differences in our opinions. The divergence in our views is not rooted in a lack of understanding, but deeply held convictions that each of us carry, ultimately leading to a point where consensus is unattainable. The judge, however, Judge Cannone, sending the jury back using the Tucci-Rodriguez rule. It's also known as the dynamite charge, which has her strictly saying to them, please, there is no jury who can do a better job than
You got to feel,
we need
I mean,
a verdict in this
it's not
case.
a not guilty.
They came back then at 2:30, and the note says, despite rigorous efforts, our perspectives are firmly divided. And they went to go on to say some feel very strongly that there has been proof beyond a reasonable doubt. Others, the exact opposite, that there has not been proof.
Football rise.
And now we have an official
I mean, he did.
ruling
Yeah, he did
in the
smile
Karen
at her.
Reed murder trial.
I mean, I don't know. I mean,
it is a mistrial declared. And
I
you see
heard,
there,
and like,
Karen
I'm
Reed
not
her father
privy to any
came
sort of
now-
information, but I heard that part of John O'Keefe's family did not believe that she was
And now
guilty.
we have an official ruling in the Karen Reed murder trial. It is a mistrial. Jackson's hand. Behind him in the
I think
red
the mom
tie
really
is
did.
attorney David Yannetti.
But again, I don't know these
O'Keefe
people.
family, who seemed, that's his mother right there in the blue and white striped
I just love
shirt
how
in the
Jackson's
far
like, I'm getting
background
back
that you can see also
to
hugging.
LA.
They seemed rather emotional
I am
today.
out of this.
A mistrial
I am
after
back
two
where it
notes.
makes
The
sense.
first one came in at 11:30, saying in part, we find ourselves divided by fundamental differences in our opinions. The divergence in our views is not carry. Ultimately, however, Judge might charge, which
I'm not
has her
surprised though that they were
strictly
split.
saying to them, please, case. They came back then at 2:30, and the note says, despite rigorous efforts, our perspectives are firmly divided. And they went to go on to say some feel very strongly that there has been proof beyond a reasonable doubt.
That's wild.
Others, the exact opposite, that there has not been proof beyond a reasonable doubt. This indicates that most likely it is more than just one juror.
Everybody
who is
say
the
goodbye.
holdout in the division among these 12 jurors, 6 women, 6 men. And it says,
We
since
salute you for
adherence
your
to our
service,
convictions
OnlyFan.
are deeply held beliefs, that this would not be worthwhile to continue to deliberate. This is after 9 weeks of testimony, more than 600 pieces of evidence, 29 days of testimony, and they spent about 5 days deliberating. The Commonwealth was charging Miss Reed with second-degree murder, motor vehicle manslaughter while driving under the influence, leaving the scene of a collision causing death. Manslaughter was also, as you see, motor vehicle manslaughter, but the lesser included charges were in there as well. The jury's instructions from the judge was that you can't argue with the law. It's not what you want it to be. It's what it is. The presumed innocence of Miss Reed, unless proven beyond a reasonable doubt. She doesn't have to explain herself or provide any evidence at all. That is up to the prosecution. And again, what it appears to be, and until we hear from the jurors or Judge Cannone herself, what it appears to be is that there was a deep division, more than one, within this jury of 12 who could not come to an agreement as to her guilt or innocence. She went on to make sure that the must be unanimous under reasonable doubt doesn't mean proof beyond all possible doubt. You need to have moral certainty. If after looking at all the evidence, you do have reasonable doubt, then the defendant is entitled to the benefit of that doubt and must be acquitted. Still,
Jeremy
despite
Cochran.
all of that, they could not come to a conclusion. They had a half day of deliberations on Tuesday after closing arguments by both the prosecution and the defense. They deliberated Wednesday, let off a little early around 4, until 4:30. In there at 9.
Let's fast forward and see where we're at.
LA.
Jackson. Yeah, there we go.
declare this mistrial. There's been one juror who has been crying on a regular basis when she goes into the courtroom.
Sue, we're gonna cut in and listen to Alan Jackson. Hold one moment. All right, we can't seem to hear it. We are recording this right now. Of course, we'll get it to you. Sue, continue to talk to me about the relief that you say the jurors felt, or at least
I mean, they have been a pretty poker-faced looking crowd all through. I mean, occasionally, as we've been reporting on Canton Confidential, we see faces, they make motions, and we can only, guess what we think that is based on our human experience. But today, they actually came in looking bleary-eyed, looking like they had the weight of the world on their shoulders. And when they came in this afternoon, there was absolutely no doubt about it that they had tried as hard as they could. Everyone in the courthouse, all the people that I have talked to, have talked about how hard this jury has worked, and that there should be in no way, shape, or form any look at that they didn't complete the task that was given to them for whatever reason. Obviously, we will learn more about what went on in the jury room when we find out who the jurors were and if some of them would like to talk to us. But there was a feeling of relief. And also, some jurors looked really pained when they were walking out. Certainly, again, we don't know what the issue was. We don't know how many people are split. But they walked out feeling, I think, by looking at them, that they had worked really hard, and some of them were pained and looked disappointed that they didn't get to the conclusion that they were hoping for, JC.
Sue, what about the O'Keefe family? I could see Mrs. O'Keefe in the background. She's been emotional, but not overly so. I imagine that she saw this coming, as we all sort of did, based on the note that was sent to the judge on Friday and then again this morning. But did you get any sense from the O'Keefe family what this verdict meant to them?
I saw them when they walked into the courtroom, JC. I didn't get to see their faces when the judge declared the mistrial or basically said that the jurors were stuck and they weren't going to go further, and then declared a mistrial. But, coming in, you can just imagine the trudging in, back and forth, waiting to see if there's going to be the answer that you hope for. They did look like that this has been really just wearing them down. You could probably hear the cheers in the distance of the Karen Reed supporters, but all in all, this has been just very difficult for them, and you could tell by the weight of the world on their shoulders as well. I talked to a number of law enforcement outside today, and they were just saying that regardless of the verdict, the fact that they're not going to get any sort of closure or idea of what might have happened to John O'Keefe is really part of the great tragedy here. And as we have tried to keeping the idea and that John O'Keefe is the victim here. He died tragically, and at this moment, we're not going to know why, and at this moment, no one is being held accountable, JC.
Sue, stay right there. We have Michael Coyne, our legal expert, on the phone. Michael, Judge Cannone did say that they would reconvene July 22nd at 2 p.m. to figure out what comes next. So you tell us, what comes next in something like this?
Well, the prosecution will have to decide whether they want to retry her or not, and I expect that they will decide to retry her. It's the police officer, and the prosecution feels strongly that their case is correct, that they've got the right defendant. And so then the question becomes, will the defense attorneys be able to come back? Can they fit it into their schedule? The financial issue becomes a question as well. And then ultimately, how do their schedules all work as to when this might be retried? There's always the possibility that the government might decide not to pursue a second trial. I don't think that's likely. There's also an unlikely possibility that they could strike a deal as well. Again, I think that's an unlikely possibility here, JC.
Let me just ask you, how much say does the O'Keefe family have when it comes to the prosecution's decision whether or not to retry?
Not a lot. I think obviously the district attorney would take into account their feelings, but either whether they were strongly one way or the other wouldn't necessarily be dispositive. As the chief law enforcement officer for Norfolk County, he has a responsibility to everyone involved to really take a hard look at the case and see whether it makes sense to go forward again.
All right, Michael, joining me now on the set is Glenn Jones. Glenn, as you heard, that has been declared officially a mistrial, which is where we were leading based on the jury's note to Judge Cannone on Friday late in the day, and then this morning, and then here we are, 2:30, they came in and declared yes.
I suppose at this point we can't be entirely surprised that this is where things ended, especially with how eloquent and articulate the notes were from the jury. And here we go. I expect, as Michael Coyne just said, that we'll be here doing this again because, of course, there is a victim in this case and there's no accountability yet for his death.
Michael, are you still with us on the phone? Michael,
I am, JC.
I just wanted to ask you, and this is a Monday morning quarterback kind of question, but it's also just off the top of your head. This was a 9-week trial with more than 70 plus witnesses. If this were to be retried, could we think that the prosecution might have the ability to cut that in half and perhaps take a slightly different approach to this?
I think you're absolutely right. If it's tried again, they have to cut it in half. They have to boil it down to the essential parts of the case as they see it, which should be the excessive drinking, the driving, and then obviously tying his death more closely to her actions than they did in this case, in all likelihood. The fact is that the jury must have struggled with some of these issues. And so the government gets a chance to have a do-over here and fix the mistakes they made. To me, this is a win for the government simply because the defendant's resources were likely drained at this point.
Really?
Most of us thought that this would likely be a not guilty verdict. So to have the chance to correct the mistakes that we saw during the first trial, this is, if they're going to retry her, they all, in almost all likelihood, will have a significantly different case that will be mightily pared down from the last
Did everyone
case.
say bye to
Okay, Michael,
OnlyFans?
thank you. Stay with us. Let's go now to Dedham and NBC 10 courtroom insider Sue O'Connor.
Wild.
Braving the weather conditions there for us, Sue. We've been talking on Canton Confidential about the likelihood that this jury had to wade through so much evidence. And of course, that is still true. But I wonder, Sue, what you think was happening in that jury room now that we know that people were kind of dug in on their personal beliefs and the rhetorical arguments that must have been ensuing inside that jury room.
Right. What we heard, Glenn, from the jurors' note, right, was that it wasn't about the evidence. It was a different interpretation of the evidence. It was, if I remember what they said correctly, that some felt it met the burden of proof and some said that it left too much reasonable doubt. And we had heard earlier I think the note from this morning from the jury that there was a deeply held convictions, or there were deeply held convictions, that it wasn't that they hadn't worked hard enough. It wasn't that they hadn't evaluated the evidence. It wasn't that they hadn't thought hard about this. That 1, 2, we don't know how many jurors had come down to a decision that the other jurors disagreed with, and there was no moving them. So some immediate questions I have about that was that if there is indeed some deeply held conviction, and remember, we don't know if they were disagreeing about charges, the lesser charges, we don't know if they were disagreeing about guilty or not guilty, we don't know what the numbers are in the split. But, and I also think that the foreman was also being somewhat diplomatic by the way that the letters were written, the notes were written. We can't intuit what the numbers are there. So having said that, saying someone has, or some jurors have, a deeply held conviction,
wild.
I'm wondering if that was something that maybe should have been vetted out during the voir dire of the witnesses. For example, I'm a commentator, so I could tell you this. I'm against the death penalty. So I would be unable to serve on a jury if death penalty was on the table. That's fine. That's the law of the land, but I would be vetted out of that. So I'm curious to find out what this strongly held conviction is that one or more jurors have. And I'm also just really very curious to find out if it breaks down between a not guilty versus guilty, or if there were some of the lesser charges that really broke it up. Glenn and JC.
All right, Sue, thank you very much. Now we want to just go out to what the defense had to say when they walked out of court. Sue, take a listen in, as well as our viewers here.
Judge Cannone, despite our rigorous efforts, we continue to find establish the necessary elements of the charges. The deep division is not due to a lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. I'm not going to do that to you folks. Your service is complete. I'm declaring a mistrial in this case.
Folks, this is what it looks like when you bring false charges against an innocent person. The Commonwealth did their worst. They brought the weight of the state.
She's like, yeah.
Charges based on compromised investigation and
Woof.
investigators and compromised witnesses. This is what it looks like. And guess what? They failed. They failed miserably, and they'll continue to fail. No matter how long it takes, no matter how long they keep trying, we will not stop fighting. We have no quit. Go ahead.
I just have two things to say, folks. Number one, I am in awe of the strength and courage of this remarkable client that I've had the privilege of representing since day one. And number two, I want to send a message to all of her supporters out there. Your support was invaluable. We are touched, and we ask for your continued support. I'm not from Texas, like my colleague here. I'm a Boston kid, but I'll repeat what he said, which is, we ain't got no quit.
There you were hearing from the
He's
defense
from California.
team, both David Yannetti and Alan Jackson, which, by the way, Alan Jackson is based out of Los Angeles. Whether or not he will continue on the case, there was a reporter who yelled that out. We don't know, but we just did get this press release in from the district attorney's office that did say, we thank the O'Keefe family for their commitment and dedication to this long process. They maintain sight of the true core of this case to find justice for John O'Keefe. And Glenn, of course, the most important line is the last one. The Commonwealth intends to retry this case.
Get out of
It's
here.
Significant for two reasons, JC. Of course, the last point that you made, they intend to retry this case. They believe they have a winnable case. But the second is, we haven't heard from the state since this trial began because they stay quiet during the process of the trial. Now that the trial is over, we're hearing from them, and they at minimum have enough confidence to try this case again.
We will see how they will do it again. Judge Cannone has July 22nd down. So we really have to wait, at least 3 weeks, a little over 3 weeks until 2 o'clock at that day to decide to hear from both sides. She didn't want to wait any longer than that. Yannetti, the defense attorney, was trying to push it possibly into August, and Judge Cannone said, no, we're doing this sooner rather than later. Kirsten Glavin has been following this trial.
She's not playing
for
any
us
games.
all along. Kirsten, how have things been outside the courtroom after this announcement?
JC, as soon as the announcement came down that this was in fact a mistrial, we did hear a round of applause, but also a lot of different emotions from people in the Free Karen Read movement. A lot of people had been anticipating this as the outcome of this trial, but obviously it wasn't what everybody wanted. Now, I am here with Paul Cristoforo, who has been organizing a lot of the Free Karen Read movement throughout all of this. What is your initial reaction right now?
My initial reaction was there wasn't a guilty sentence in there. Out of the 12 people that were in there, they couldn't find enough people to find her guilty. And it was a mistrial, not because of illegal fraud, not because they couldn't convince 12 people that Reed was guilty.
Is that for you, or is this what you expected? What's going through your mind?
My initial expectation was automatic, not guilty. But as we learned this case, nothing happens the way it's supposed to happen. So am I satisfied with it? With the mistrial right now? Yes. But do I want more? Absolutely.
Now, what are you looking forward to moving forward? Where do things go for your movement from here? I know a lot of people have been saying they're going to stand by Karen no matter what happens.
Yeah. As far as our movement goes, we are going to stand by Karen. We do have some more work to do. We learned a lot of stuff that happened during this trial within the Mass State Police and the Norfolk District Attorney's Office, and we're going to move forward with that.
I've also been speaking with a lot of people in the group, and a lot of them do not think that this case is going to be retried. Have you put thought into that? Is that something that you would like to see happen, not happen? Where are we on that point?
I don't think the case will be retried. there's not enough evidence. It's a lot of money for the state. They're probably going to lose some of their key witnesses for some of their behavior. What I really want to see happen is to reopen the case and find the true killers of Officer John O'Keefe.
Paul, thank you. I appreciate it. We'll catch up with you in a little bit. I do also want to add that there were a number of people here earlier today opposing those in the Free Karen Reed movement. A lot of them saying they also wanted justice for John O'Keefe, but that justice looked a lot different than what the Free Karen Reed group had wanted. We did also hear a lot of talk about the federal investigation into this case. That is still ongoing at this point. So a lot of people, especially in the Free Karen Reed movement, did want to see more come of that as we move forward. But obviously a very developing situation here in Dedham. I'm going to send it back to you inside this.
All right, NBC 10's Kirsten Glavin. Kirsten, as you were working to get reaction from folks on the ground there in Dedham, we learned in the last 6 minutes that the Commonwealth will retry this case. So that is something that we're going to get reaction to as the afternoon progresses. Let's go back to NBC 10 legal analyst Michael Coyne. Michael, now that we know it is the intent of the Commonwealth to retry this case, do you think that's the right call?
I do. I think that, as you pointed out there, the Commonwealth is looking for accountability for the death of John O'Keefe. They feel they have a strong case against her. Others disagree. It's a very polarizing case. But at the end of the day, it's the district attorney's responsibility to decide whether to go forward or not. And that decision has been made now. And the likelihood is what we will see is a more streamlined case directing at the core evidence that will warrant a guilty verdict. If the jurors decide to,
this is crazy.
We'll also be able to get feedback from them as to what evidence resonated with them and where they stood with respect to key pieces of evidence. So both the government and the defendant will have an opportunity then.
I think that's what the
their
Commonwealth
cases
would
the
be
second time around with that in
playing.
mind.
Is
Michael, there's
hey,
a federal investigation going on side by side. Would it
this is-
benefit
we're gonna bet
the
that she's run
Commonwealth
out of
to
money,
wait until that closes to be able to restructure
also
their prosecution?
kind of fucked, if
Yeah,
you ask me.
you would think at this point it is either closed or at an end result so that some activity should be taking place or there should be some release of the information. They really haven't done either party, either the Commonwealth or the defendant, a service here by just having this out there in the atmosphere that there's something about the federal investigation proceeding. I think the federal government, if they intend to bring charges against someone, they should. And if whatever, there should be more sunlight there as well so that we are able to see what the results of that investigation has revealed. Because it has brought a real problem and an atmosphere to this case that has made it difficult, I think, for both the defendant and the prosecution to be able to try their case completely effectively. May well have contributed to the deadlock that we have here.
Okay, Michael, thank you. In a moment, we'll ask you about finding an impartial jury for this retried case, because that could be a challenge. We'll find out, I'm sure. Let's go to NBC 10's Mary Marcos, who's also covering reaction to this mistrial ruling from Judge Beverly Cannone. Mary, what are you hearing?
Well, Glenn, when that ruling came down, the crowd erupted in cheers. The police have now blocked off much of the road here. We can't really get much further down.
I mean, it's not
because they are trying to
good for
protect
her.
the identity of the jurors who are now being sent
But it's much better than
home.
guilty.
Legal experts telling me that the prosecution will now have to make a decision, and we've heard from the statement from the DA's office, they do intend to retry Karen Reed, but legal experts told me that they expected to hear that. Whether or not they will actually retry Karen Reed, they had mixed opinions on. Either way, they will have to do that within a year from today. That's Massachusetts state law that they have to do that within a year. Within the Manuel Lopes case we saw with police officer Michael Chesna out of Weymouth, that happened within about 6 months. So either way, we will be seeing more of this within the next coming months, and we will be hearing possibly from the jurors themselves. Legal experts say they couldn't decide to
People, defense attorneys will take cases just
what were the discussions? Where did they
for
get
publicity. I believe.
So we can hear from them.
Think,
We'll have a
well,
lot
I don't know
more
if Johnny
to
Cochran
dig
did
into
it.
in this. For now, we're
There's
live
a
in Dedham.
couple
Mary
of
Marcos,
cases
NBC
where
10 Boston.
high-profile
Mayor, before
lawyers
you
are taking
run, I just wanna
cases.
ask,
Alan
we know
Dershowitz,
there's
people
been
like
a
that.
200-foot buffer zone around the courthouse.
No,
throughout this
I hope she's
trial.
not dating
Are
a
you
cop.
saying that has
I hope
been
she's learned her
expanded
lesson.
now in order to protect jurors?
Maybe just go away and be quiet and get your life back together, because this is just
I would say that that's probably more than
decompress.
200 feet where the police are keeping
Probably,
us away
probably
from
get
that.
the
So I guess
F out
perhaps
of
it has
Massachusetts.
expanded quite a bit for the meantime, just to protect the jurors' identity as they try to leave the courthouse.
Okay, understood. Mary Marcos, thank you.
Let's go out to our
Wow.
Sue O'Connell, who's been in the courtroom every day of
Unbelievable.
this 9 weeks. Sue, did you have any chance to see Karen Reed's family as they walked out and perhaps get a sense of their mood?
I think their mood is they're relieved.
I didn't, JC, because I was over here on the phone with you at the time. But I'll tell you that you could tell by Karen Reed's face when the mistrial was declared by Judge Beverly Cannone. There was not a big smile, but there was definitely a look of relief. We could tell over the days that this trial is coming on, she was looking more stressed. People have certainly been commenting about her demeanor in the courtroom and how it was being, some
Yeah,
thought
she's
and
gotta be
said it was
exhausted.
disrespectful to the O'Keefe family and to the death
I'm
of John
tired
O'Keefe. But
of
over the
this.
past few days, it has definitely been tightening up and getting more stressed. And her family as well, her parents also looking more and more put upon and more
Unbelievable.
burdened as this trial was going on. So when that happened, it's an odd
I
thing,
don't know if she's
right?
still
The
under
judge
bond, is
declares a
she?
mistrial. This is the thing we have been
That's a
waiting
great
for.
question. Don't know the answer to that.
And then they immediately go to sort of administrative business that they have to do. So there's no moment of release or relief or celebration or mourning or whatever emotion you would have in the courtroom. You then have to sit and listen to David Yannetti, the lawyer for the defense, talk about what week his vacation is. And Judge Beverly Cannone is teaching that week. And Andrew and Alan Jackson and Eliza Little are unavailable and will be attending by Zoom. So there's this big moment. Get our calendars out. So the feeling within the courtroom did still feel very still and very tight.
What do you guys
But
think?
when they came out, you could see them on the steps. The Reed
Are
family,
you relieved?
Karen Reed and her defense attorneys, definitely still full of fight. I think anticipating that another trial was going to come and setting the tone for that.
Sue, when you're not our courtroom
Oh,
insider, you're
he's the
our
dean of
political
business
commentator.
college.
So let me
Interesting.
ask you about the political calculus
Well, that would be
goes into
that'd be why she probably has a
Michael
job there.
Morrissey's decision to retry this case.
No,
Of
I mean,
course,
not
he's
that
an
she's not
elected
qualified,
official,
but
and I
nepotism
would
is a real
imagine
thing.
that the next election must be in his mind when he's making this decision.
Oh, I'd imagine covering
I'll tell
another
you, Glenn,
next.
that
They're
one
too
of the
busy.
things that I have heard
Oh no,
from people all
we'll
up
be
and
back
down
at
the
it.
street, and because it's mostly
I don't know
Karen
if we'll
Reed
be back at it
supporters,
tomorrow.
very few people for a counter protest.
Yeah, I
or
think it is
supporting the O'Keefe
I think we'll
family
start
who've
with the
been
Baldwin
outside. So I
trial
just want to say that up front.
next
It's
week. I think
mostly
that might be a
Karen Reed
possible
supporters
thing.
that
We
I've
have,
talked to. Many of them
and I'll be
were
doing some
learning
analysis
for
on
the
this
first time how our justice system
later.
works, and that it's the district attorney and it's the district
Yeah, she's a
attorney's
financial
office and how
analyst
important
at
district
Fidelity.
attorneys are. We know
But that doesn't mean she has an
Suffolk
unlimited
County,
amount of money
and
to pull
across
to
parts of
continue
the urban areas of
dealing
Massachusetts. The
with
ACLU
this.
had run a program a few years ago called What a Difference a DA Makes. And that was in regard to responding to Black Lives Matter concerns about how overcharged Black and Brown people are within the Commonwealth. So for many of these people, for the first time, they were understanding that that's an elected office, that Morrissey could in fact be elected out of the office. So the deeper part of the reaction of the what I have sometimes called
There's more. There's
here,
more,
the
Court.
cheering of
You have
Karen,
no
the
idea.
lack of concern or expression for John O'Keefe and John O'Keefe's family, I think also may turn into an awareness of political power for this group, especially when it comes to his running for re-election at some point and the things that have to happen. And I've been spending a lot of time with new friends and colleagues who are working covering this from Canton Public Access Television and talking about the splits that are happening within Canton regarding their concerns about the concerns. Right now, Paul O'Keefe, John O'Keefe, O'Keefe's mother is coming down, and they have been obviously through this trial every single day some sort of justice officers, and they walk out, and obviously you don't need to
Are those the jurors?
see that they are heavy. They have also been through an enormous amount of
Yeah,
All
they've
right,
had a
Sue,
hard.
thank you. We're gonna, the shot is breaking up a little bit, so we will come back.
Oh,
to
I
you,
thought it was
but
my computer.
I appreciate the fact that you're remembering John O'Keefe and all of this, and the O'Keefe
Yeah.
family, and where really thoughts should be with is the man who lost his life at a mere
Absolutely.
46 years old on that day. We want to bring in our legal analyst one more time,
Absolutely.
Michael Coyne. Michael, there is no question this is a high-profile case. We know when we cover it through our Canton Confidential, the Karen Reed murder trial newscast at 7 o'clock, through our podcast, that we have viewers now coming from across the country, and in some cases across the world. If within a year they need to seat another jury of at least 12 people, how do they do that in a way where they do
I think
not
they were.
already have an opinion about this case?
Maybe.
Because every day Judge Cannone started with the same three questions. Did you hear anything? Did you see anything? Let us know if you have outside influences on the case. What do you say to that?
Well, it's going to be a challenge. There's no doubt about it. You're not entitled to a jury that knows nothing about the case and hasn't been exposed to anything. What you are entitled to have is a jury that is, despite what they know, despite what they've heard, is willing to rule only on the evidence submitted at trial. And it will be a challenge because of the widespread publicity this case has and its polarizing nature, to find jurors who will be able to put aside whatever they have already heard and decide it solely on the evidence. But, you know, around here, we've tried a lot of high-profile cases, whether it's Whitey Bulger or Aaron Hernandez or the Marathon Bomber. And the judges will have to take special pains, because even in the Marathon bombing case now, the appeals court has sent that case back to the trial court to take another look at whether a couple of the jurors were influenced by social media and involved on social media. So it is a painstaking task that the court will have to take great effort to get it right. But hopefully they will be able to get it right. Even with all the publicity this case already had, obviously we had a jury that took their oath seriously. It's very difficult to stand in judgment of someone else, and it's a significant responsibility, but we were able to do it once. They'll have to try and do it again, and hopefully they'll have a jury that will be able to come to a unanimous decision next time.
The publicity that you and JC were just talking about, Michael, is really just one way in which this trial was so unusual. When you look back on this, what will you remember as being so atypical of all the trials that you've seen in the past? Of course, we had the courtroom change because of jury sightlines. We've had a parallel federal investigation. There was a third-party culprit defense floated. All of these things are so unusual.
Incredibly unusual, Glenn. I think what my takeaway, at least for now, is the question about whether bloggers and social media and all of the activity we've seen from the non-traditional media has really changed the way people view justice and our justice system, and whether those folks will stay around to make sure that justice in other cases is carried out as well. So I wonder to what extent this has really changed the way people view trials and view the justice system. And let's hope that it's in a positive. More often we're going to see people who really care about justice, not just for Karen.
Well, I'm sure she's got to be broke, but I'm sure she would have no trouble
don't often see it.
raising the money again.
Yeah, Michael, stay with us. Your analysis has been so helpful as we
Now that all the eyes
process this
are
mistrial ruling.
And it's also
from
would suck
Judge
if she had no
Beverly
money to live.
Cannone,
Yeah,
and we
absolutely.
prepare
I mean, her life
for
is
a second
completely
trial.
torn upside
All
down.
right, let's bring in Peter Ellikin, also a legal analyst. Peter, the Commonwealth has already said that they are going to or intend to retry the case. What happens next when we get to this next date of July 22nd?
Well, actually, we haven't quite got a timeline yet on this, and boy, the prosecution did jump to that answer quick, because that was one of three options. They could decide not to retry it again. They could offer some kind of plea bargain. I don't know if that would go where they kind of compromise on things, or they retry it. And I guess they jumped ahead to a retrial. It is not definite, though, when all the parties and the players will be ready. Sometimes you have a case like this, it's retried, 5 months later, a year later, and particularly if the person's not being held in custody. So I I just think I'm as probably up in the air at this moment as everybody else, exactly the specific protocol and game plan that they're going to follow.
Peter, when we had you in on Canton Confidential, you were one of many that was critical of the prosecution's case. And we've talked some this afternoon about how they might switch up their strategy for a second trial. Do you think the defense needs to be different in any way once we go at this a second time?
Yes.
You know what? I want to
Don't
listen.
bring
to,
the conspiracy.
And
Just
this
focus
may
on the
sound like a
terrible
super
police work.
weaselly, lawyer answer, trying to dodge the question, but I would love it if we can really hear from the jurors to see where they were at, what they thought the weak points or not are. And again,
Absolutely,
we
Maris.
don't know, and they're under no obligation to talk, but usually somebody winds up talking, at least to the reporters. And I'm really curious, were there like 10 people for acquittal or 10 people for finding guilty, or were they evenly divided? And I think that may give us a bit of a roadmap if we can actually find out what they did, and then see if I was defense counsel, I'd want to say, oh, this is where I could have been done better, or not.
No, that's a good point. I think all of us would like to hear from people who were in that room, JC. That would give us so much insight.
Of course, that will be up to each individual juror. Thank you, Peter Ellikin. We want to go out to
8-4.
Mary Marcos. Mary, I know it's raining outside.
9-3.
However, how many people are still milling around? Because a big part of the draw of this case has been people wanting to talk to other people about their thoughts, people coming together to, whether it's debate or to unite on one side or the other. What's happening around you?
Well, right now, JC, a lot of the crowd has dispersed. My
Heavy on the
photographer
9
kinda give
guilty
you a
side, by the
pan
way.
look
Not
around, but
nine
you can
guilty,
see that
three
there's still a lot of
three
news crews
innocent.
obviously out here. The barricades remain up, and the traffic is actually now moving freely again. They had closed down the roads for a bit as the news
lower
rang
number
out
would
and
be
people were
the
cheering
guilty
in the-
verdict.
right on the sides
I
of
think
the
the
streets.
overwhelming majority
And
was like, this is
that crowd has
ridiculous.
pretty much dispersed at this point. We did see a bus presumably carrying some jurors drive off.
Oh
From
no,
the
I'm
back
just
of the
no,
courthouse.
that's not
Again, St.
fact.
Police
I'm
have
just
been
speculating.
very adamant about protecting their identities, because if and when they do decide to speak out, that is a danger to them. Legal experts tell me that, this has been such a divisive case. People have taken both sides.
I hope
and
everyone
that
leaves her alone, by the
speaking
way.
out for a juror could be dangerous. It could mean threats. It could mean, we do see a lot of those threats on social media as well. So that is a danger to them if
Yes.
they do decide
They're going to get threatened
potentially
and
to
all
speak
that,
out.
which
But of
is
course,
just
everyone
terrible.
is wondering what
I hope people leave
happened,
Karen
what
Reed and
was
her
being
family
said
alone,
in
and the
those
O'Keefes
four
alone,
walls
and
while they were deliberating, and we
that's
hope
it.
to learn that at some point. And in the
They need a
meantime, we'll
break.
continue digging into the next steps, as you've heard our legal experts speak to in this case, as the judge has declared a mistrial. Live in Dedham, Mary Marcos, NBC 10 Boston.
All right, Mary, thank you. So as Mary said, the crowd is starting to thin out. So let's take a listen to
Oh, yeah.
that crowd
They're
when it
probably
was
over
announced
it.
by Judge Cannone that it was indeed a mistrial.
I was hoping that she would be exonerated. Yeah, and it is disappointing. But I have every confidence in the justice system to bring about the right result. So on that note, I just wish them all the best and hopefully for a better result if they do retry it.
All right, let's go to Sue O'Connell, who has been inside the courtroom every day of this trial. Sue, Michael Morrissey just put out a statement. Glenn, if you want to read what the DA had to say after the verdict here of mistrial in the case
Melanie,
of
it's
Karen Reed.
crying.
Yeah, this is the statement from Michael Morrissey's office just a few minutes before 3 o'clock. He says, first, we thank the O'Keefe family for their commitment and dedication to this long process. They maintained sight of the true core of this case to find justice for John O'Keefe. The Commonwealth intends to retry the case. After the mistrial was declared, Sue, I would not have been able to predict that the Commonwealth would this quickly come out with a statement that says they intend to retry this
I know,
case.
right?
At videos
That's
there
so
of
weird.
Paul O'Keefe, the brother of John O'Keefe, getting into a vehicle there outside the VFW. I think that is in Dedham
That's his
as
mother
well.
right there.
Yes. Rest of the family too. So, Sue, were you equally surprised that we would hear from the DA's office so quickly?
Yeah, I was, Glenn, and I'll tell you, I'm hoping that they have seen and at least understand what the jurors were split on before making that decision. I assume that they have been. Without enough information about knowing what the split is, I think it could be sort of a rush there to retry this. It certainly energizes and gives the defense and the Karen Reed supporters more time to get together. I mean, again, we all keep talking about this federal investigation into this case, into the handling of this case, how that might have impacted the jurors if they had known about it. Now we certainly have been talking about it every station, every outlet, every blogger as this case has gone on. So that's going to be another element in jury selection. Have you heard about the federal investigation? What do you know about about Trooper Proctor? So those elements are surprising to me, that without a full accounting of how the jurors were voting, how they were split, it's surprising. So I assume they have information that we don't have when they move forward on this. Glenn?
And so, as you've listened to the defense throughout this trial, and of course we heard them briefly on the steps of the courthouse afterward, do you think internally, in their private moments, they are considering this a victory for their side?
Oh, absolutely. It's a victory for the defense. I mean, what it means is they were able, remember, they only had to convince one juror that Karen Reed was not guilty. And clearly, through this hung jury, they were able to do that. So that is a definite success for them. And now they've also got all the information about what they say is the evidence of the case out into the public. That's a victory for them. And as I said, you know, potential jurors will probably know about the federal investigation into the handling of the case. That's also a victory for them moving forward. So, you know, given the options of what it could have been, if it's not a complete not guilty across all the charges, including the lesser charges, this is definitely a victory for them.
Sue, thank you. We want to listen in. We've seen, as you can see, David Yannetti went to the press right there. Alan Jackson, the defense attorney, also did. We want to listen in for viewers who may have missed it. This is what they had to say when they walked outside of court.
Folks, this is what it looks like when you bring false charges against an innocent person. The Commonwealth did their worst. They brought the weight of the state based on spurious charges, based on compromised investigation and investigators and compromised witnesses. This is what it looks like. And guess what? They failed. They failed miserably, and they'll continue to fail. No matter how long it takes, no matter how long they keep trying, we will not stop fighting. We have no quit. Go ahead.
I just have two things to say, folks. Number one, I am in awe of the strength and courage of this remarkable client that I've had the privilege of representing since day one. And number two, I want to send a message to all of her supporters out there. Your support was invaluable. We are touched, and we ask for your continued support. I'm not from Texas, like my colleague here. I'm a Boston kid, but I'll repeat what he said, which is, we ain't got no quit.
That was the defense team outside of court right after the mistrial. We want to go now back to Michael Coyne, Dean at the Massachusetts School of Law and our legal expert. Michael, one of the questions I wanted to ask you was about a scheduling question. They are going to come together again on July 22nd. If they're going to retry, my understanding is they have to do it within a year, but we also know Judge Cannone has another large high-profile case on the docket. That would be the Brian Walsh case coming up at the end of the year. Do we go with a different juror? How does that work? Different lawyers, perchance, for the defense?
Well, that's the real question, is how are we going to fit this in, trying it within a year? You know, most trials don't take the length of this one. So even though there are other trials on Judge Cannone's docket, you should be able to fit this in within a year. We're talking quite a period of time here. But it would be also the question of coordinating two very busy trial schedules for Attorney Yannetti and Attorney Jackson. But at some point, you were able to work this out and move forward. They're not really going to have a choice, because the district attorney has said he intends to move forward with the pre-trial, just as he did with Manuel Lopes. And by the way, just as when Alan Jackson was the district attorney out in L.A., the first trial for Phil Spector ended up in a mistrial, and the second trial, when he was the prosecutor, he was able to convict him of murder. So it's not unusual that you're going to have a retrial within some limited period of time, and potentially with a different result.
And another way this is so peculiar, Michael, is because when the second trial happens, the cast of characters might be in a completely different place. We know at least some of those witnesses are under the specter of a federal investigation. If the U.S. Attorney's Office decides to take some action against those people before the next trial, this could look completely different.
Season 2 could be very different from the first season here. You might see different lawyers. You will see some different witnesses, no doubt, if they're all smart with respect to how this case is presented. And you'll see a lot fewer witnesses, I would expect, from the government standpoint as well. And there'll also be likely some additional expert witnesses with respect to the technology issues that we all had questions about here that were never fully resolved.
All right, NBC 10 legal analyst Michael Coyne, thanks for being with us since the beginning. We go all the way back to the spring, and now here we are in the summer. NBC 10 courtroom insider Sue O'Connell has been along for the entire journey as well. Sue, what are your thoughts as we prepare to do this all over again?
Yeah, Glenn, I just want to take a moment to acknowledge the great staff at the courthouse, both inside and outside. If you're following along on social media, you know there was some mishigas in the line with the press, and some people were very well behaved. But all along, the folks that worked inside the courthouse worked really hard to make sure we got as much access as we can. The court officers were polite and friendly and gave us as much information as they can. So, and the state police outside, both trying to enforce the buffer zone and allowing people to, just live their lives. And the people of this Dedham neighborhood who have been putting up with this for quite a while there's one dog that I've been watching. This woman and her dog walk 3 times a day. The dog has been disturbed because this hasn't been his usual route. But we've just been imposing, it's justice, it's what's happened, it's our justice system, but we've been imposing on the neighborhood. And I just wanted to give a shout out to the court staff because they have been exceptional here on the ground with us, and wanted to take a moment because it looks like if we have to do it all over again, we'll be with them again, Glenn.
Okay, Sue, thank you. We appreciate all of your coverage of this trial, which started, JC, on April 29th. And here we are on July 1st. As I look at my watch, because it's hard to keep track, we have finally gotten to the end of this first journey in the search of justice for John O'Keefe.
Please continue.
Yeah, a Boston police officer for 16 years, 46 years old. And at this point, there has been no accountability for his death.
2.5 years since his death. It was January 29th, 2022, and here we are on July 1st, 2024, and they will have to retrial if they decide to retry this case within a year. And your questions will be, will it be as long? Michael Coyne, our legal expert, just said it is unusual to have this lengthy a case. It was 9 weeks. There were over 600 pieces of evidence. There were 74 witnesses. And that is a tremendous amount of information for that 12 jurors to take in. And despite that, they said those 12 jurors, when they went to the judge, said it wasn't the law that they were having a problem with. It was the convictions of the two sides who would not budge on what they believed to be reasonable doubt and whether or not the prosecution had reached that burden. And that's why you see right there, you can see Karen Reed hugging her mother and father and remembering that the John O'Keefe family, the O'Keefes who have sat there also every day during the 29 days of testimony, during the 9 weeks, they have sat in that room listening and hearing what happened to their son and seeing the evidence and seeing the autopsy photos. And they walk out with no conclusion to this, only to the idea that the DA, Michael Morrissey, is saying their intention is to retry this case.
And after learning of that mistrial ruling today from Judge Beverly Cannone, we then heard, as you mentioned, the retry. And now it's going to be interesting to see if the jurors actually help us understand what was happening inside that room. And if they do, it will really set up the prosecution and the defense to retry this case, potentially in a way far different than they did the first time around.
7 p.m., Canton Confidential.
Absolutely.
The two of us are there with all of our experts. There's certainly a lot more to talk about.
And we'll see you as well for the news at 4.
Straight and keep their eyes on the prize. Yes. Okay, so you actually got to shoot in Ireland, right?
Yeah, we did. It was
I
so
love
beautiful.
No, I hope those stupid people didn't just wreck my
All right, wait, are you still there?
financial live stream playing the stupid Kelly Clarkson show for 4 seconds. I was just listening to Mark Betterow and Melanie Little chat about everything while I was on mute. So Mark Betterow was just sharing on her show that just because they say they're going to retry it doesn't mean they're going to retry it. They have to say that. So a lot will happen, and we'll see all that. We'll see what happens. But yeah, it is not. She walks free. It'll be another 6 to 9 months of her just kind of living under the same thing she's been living under for the past 2.5 years. So she walks out free today. We'll see what that does. There's also if the federal case ends up being a thing, that they could in fact stop the retrial if they end up doing it. But again, the prosecution has said that they will retry it, but that doesn't mean they actually will retry it. So they kind of have to say that, at least according to Mark Betterow, who was just on Melanie Little's channel chatting all of this. So that's the word, movers. Wow, we get through another one. What a day. What a day. What a day. What a day. It's also doesn't seem to be yes, Ashley Banfield, yes. And I'll probably come back later on tonight and talk about this as well. We'll see if I can get anybody to come on the show with me. And unbelievable, but hey, better than a guilty verdict. Better than a guilty verdict for Karen Reed. Again, John's family doesn't get the closure. I think. Thank you so much. I appreciate that. The 50K. Thank you so much, Cybele. I'll be around. Don't worry. There's lots more content coming out from me. As you guys know, and you see, I make VOD or the regular non-live content for you guys, which I really enjoy. So you'll be seeing a lot more of that. I'm so grateful to all my 50,000 subs. It's been amazing. Karen Reed trial has been an education for me. That is for sure. Sitting here with y'all. Sometimes we had up to 1,000 people on here. It's been an education on the legal system, I think, for all of us. And also, I think it's been a positive experience for me. I'm looking forward to getting some sleep in tomorrow morning. Maybe a couple hours sleep in. But anyways, Mover Nation, we get through another one, please. It's going to be crazy out in them streets. It's going to be crazy. But please, as I always say, try, be kind to one another. Don't let this absorb your day. For right now, it is, it's the end of the line right now for Karen Reed until July 22nd when they have their next hearing. And then we'll see what happens in the following weeks, days, and months to come. But until then, be kind to one another, care about one another, and do something positive. And hey, I'll see you all very soon. Thank you so much for 50K. Here's the outro. Mover Nation, thank you so much for watching. Thank you so much to all my channel members and Patreon supporters. And for more exclusive content, behind the scenes videos, monthly VIP meet and greets, and watch parties, please consider supporting me on Patreon or by becoming a YouTube channel member. If you like this video, check out this one right here or this one right here. And don't forget to like and subscribe because it helps with the algorithm. On that note, I'm Collier Landry. I'll see you on the next one. Good girl, Marisol. Good girl.